Okay, I want to talk about the very exciting topic, but very important topic of defense medical exams, sometimes called independent medical exams, IME. I call them defense medical exams, DME, because are they independent? Hell no. But I'll talk about that in just a little bit. A couple of different things. In California, at least, it's governed by the Code of Civil Procedure, Section 2034. So the defense is entitled to legally one medical exam, right? And in that medical exam, they are not allowed to do any kind of invasive treatment. They can't take x-rays, they can't take scans, they can't do injections, etc. Right? However, they can request additional DMEs if you're making claims about different body parts. And I just got a question yesterday of, hey, the defense is asking for a defense medical exam for the knee and for the spine. Should I allow it? And my question to them was, well, do you want $1,000,000 plus? Yes. I'm like, well, the judge is going to grant that. And so instead of fighting something you're going to lose, don't you want them to have the requisite information if you want to try to settle that case? Because if you're successful in preventing them from doing a spine DME as well as a knee DME, and then you're asking for money for their spinal injury, they're much, much less likely to be able to go get you money because they don't have the requisite information. Right? Well, but then they'll be at a disadvantage and then et cetera. That is way, way, way overblown. But whenever a medical exam happens, within 30 days, if you request it, and again, whenever we get a request for a defense medical exam, we have a form that goes out that says, we don't really object, but we do say this is a request that you are required to write a report, and you write the report. At the medical exam, you're entitled to have someone go and watch, someone go and intercede if something goes wrong. My philosophy is that I do not really have that person interfere with the questioning. I know there's a concern about, well, what if they're going to do a second deposition? What if they're going to do, an inquisition about the facts of the accident, et cetera, right? That is, again, very, very, very few and far between. Has it ever been a problem? Much more common is the problem that the observer interferes with the history, and then the defense expert is like, well, I was interfered with. I couldn't get that information. And that actually hurts you more than whatever perceived second bite at the apple they get. So I don't really object, but I also don't go myself or have a lawyer go to the exam. And the reason for that is that, one, the exam is being audio taped. Two, I want someone with a medical background, a registered nurse, sometimes a chiropractor. We use registered nurses who are actually way more knowledgeable than any lawyer about what has been excluded, how the testing is done, if it's done properly, if there's cheating, et cetera. But if I need to authenticate that audio recording, if I need to authenticate how long the exam took or didn't take, the doctor says, well, I had a 40-minute exam and it took 8 minutes. How do I get that into evidence? I need to have a witness who I can call to authenticate the audio and to authenticate the time. And I don't want it to be me. I don't want it to be a lawyer in our office. I don't really want it to be an employee of my firm, right? I want an independent person. And so for the relatively negligible de minimis cost of having that third-party examiner, it gives me quite a bit of flexibility on establishing authenticity. Okay. Next, the report that is required, if requested, to be written by the defense expert within 30 days by statute has to include, it's in 2034, has to include a conclusion, all of their opinions, their diagnosis, a description of all of the testing and the results. So when I get a report and that's not included, it tells me two things. First, well, either one of two things. Either that the defense expert is just lazy, but much more likely, they don't want to put this in the report because they would have to write things that are helpful to the plaintiff. They don't want to put their opinion that the collision caused these particular things. They don't want to give causation or give future damages. And so many times when you see that, you pushing and saying, absolutely not, this is a incorrect, insubstantial, wrong, brief report that requires all this other stuff. I need it tomorrow. You've had 30 days to prepare this report, right? Many times that might settle the case, right? But you want to push. You also want to have that more substantial report when you take the deposition of the defense expert. Because if they're required to put all the testing, required to put all the results, right? Required to put all their opinions and conclusions, you have a much better chance of one establishing, so all of these things that you found, those were at least related to what the plaintiff was saying that were consistent with what the plaintiff was saying, right? So you're not going to say the plaintiff's a liar. You're not going to say they're malingering. They're not exaggerating. The testing you did and the findings that you did are consistent with what the plaintiff's saying. So they're accurate. And you would agree, at least generally, without you agreeing to causation, that the areas in which they're complaining do correlate to the findings on the areas of problems in the scans. Now, I know you think it's degenerative, but whatever we're going to call it, that's the level that you're testing and finding that the plaintiff is truthfully talking about that stuff. So having that additional information that ties them down is very, very important, because you're going to ask your final question based on our deposition and my questions and what you've said and everything else that's included in your report. This is the entirety of your opinions, correct? Correct. So you want to tie them down, right? This is very, very important to know when you're doing defense medical exams. And the last part I want to talk about is what I mentioned at the beginning. It's called an independent medical exam, and it is everything but independent. But defense experts love to cloak themselves in the coat of independence. I'm an independent examiner. And so I find it helpful when you start your cross-examination. And, defense mentioned this is called an independent medical exam. Oh, yes, of course, independent. So you're here as an independent witness. Oh, of course, counsel. You're not advocating in any way for one side or the other. Oh, no, because it's called an independent exam. You would agree that if the jury finds that you're advocating for one side or the other, you're violating what you understand was your role in this case. Right? And if they're violating your role, would you at least agree generally that the jury would be entitled to maybe not believe you as much? Oh, well, we're going to be independent, right? So if I ask you questions and you don't want to answer them because you're independent, you're going to go ahead and answer them like you did with the defense lawyer, right? And, if you're not going to advocate, then we're all good. But if I do something where I'm advocating, point it out. But I'm going to do the same with you. Fair enough? Okay. And then later on, when you say, well, the plaintiff complained of pain, correct? And the answer is, well, pain is a subjective thing that could be imitated by the plaintiff. Wait, doc. I just asked for a yes or no question. You're not being an advocate right now, are you? I thought you were supposed to be independent. On and on. But you set the foundation, right? So that later on you can go back to that when the defense expert, who is, many of them are like the second defense lawyer, you can point it out when it's happening so that the jury can see it, but you've prepared them to show them when it happens. So if you got any more questions about medical exams, defense medical exams, sometimes called independent medical exams, please reach out. My info's in the bio or the video description.